Hello, my name is Kayleen Inoka, and today we will be discussing child abuse and the mandatory reporting laws in California. Have you ever witnessed child abuse or a child being harmed in any way and wondered, what do I do? Do I need to report this? Well, as healthcare professionals, it is important that we understand the mandatory reporting laws in California. First, what is child abuse? Child abuse and neglect is defined as physical abuse, sexual abuse, including both sexual assault and sexual exploitation, willful cruelty or unjustified punishment, unlawful corporal punishment or injury, and neglect, including both acts and omission. Under current law, child abuse does not include a mutual affray between minors, reasonable and necessary force used by a peace officer acting within the course and scope of his or her employment as a peace officer, an amount of force that is reasonable and necessary for a person employed by or engaged in a public school to quell a disturbance threatening physical injury to person or damage to property, for purposes of self-defense or to obtain possession of weapons or other dangerous objects within the control of the pupil. Now, who is mandated to report? Under CANRA, legally mandated reporters include, but are not limited to, clergy members, any custodian of records of a clergy member, child care providers, educators, law enforcement, medical professionals, mental health professionals, and commercial film and photography print processors. As you heard, medical professionals are definitely mandated to report. So, as a medical professional, you might ask yourself, when do I report? Well, child abuse must be reported when one is a legally mandated reporter, has knowledge of or observes a child in his or her professional capacity or within the scope of his or her employment whom he or she knows or reasonably suspects has been the victim of child abuse or neglect. Reasonable suspicion occurs when it is objectively reasonable for a person to entertain such a suspicion based upon facts that could cause a reasonable person in a like position, drawing when appropriate on his or her training and experience, to suspect child abuse. The intent of this definition is clear. If you suspect child abuse, report it. As a medical professional, we deal with patients on a daily basis. We see things that others may not see, and it is our duty to report what we suspect. Now, if you ever witness child abuse or suspect any child abuse, you need to know who to report to. The report must be made to a county welfare department, probation department if designated by the county to receive mandated reports, or to a police or sheriff's department, not including a school district police or security department. Reports by commercial print and photographic print processors are to be made to the law enforcement agency having jurisdiction over the case. As a healthcare professional and mandated reporter, it is our duty and responsibility to report any suspicion of child abuse. However, it's normal to feel fear of repercussions when reporting. In order to protect mandated reporters from repercussions for reporting as required, the CANRA includes specific safeguards. First, those persons legally mandated to report suspected child abuse have immunity from criminal or civil liability for reporting as required, even if the knowledge or reasonable suspicion of the abuse or neglect was acquired outside of their professional capacity or scope of employment. Mandated reporters and others acting at their direction are not liable civilly or criminally for photographing the victims and disseminating the photograph with the report. Secondly, no supervisor or administrator may impede or inhibit a report or subject the reporting person to any sanction. Third, the identity of the reporting party and the contents of the child abuse report are confidential and may only be disclosed to specified persons and agencies. And last, in the event of a In the event a civil action is brought against a mandated reporter as a result of a required or authorized report, he or she may present a claim to the State Board of Control for reasonable attorney's fees incurred in the action. If he or she prevails in the action or the court dismisses the action, failure to report suspicion of child abuse can lead to consequences. A person who fails to make a required report is guilty of a misdemeanor punishable by up to 6 months in county jail and or up to a $1,000 fine. He or she may also be found civilly liable for damages, especially if the child victim or another child is further victimized because of the failure to report. Furthermore, any mandated reporter who willfully fails to report abuse or neglect, or any person who impedes or inhibits a report of abuse or neglect, where that abuse or neglect results in death or great bodily injury, shall be punished by not more than 1 year in a county jail, by a fine of not more than $5,000, or by both that fine and imprisonment. So now that you know what child abuse is, when to report, whom to report to, the safeguards protecting mandated reporters, and the penalties for failure to report, please do your duty as a healthcare professional and report any suspicion of child abuse. The indicators of child abuse are as follows. Do the right thing. Report child abuse. The kids need you.